If not, I'll call upon the opposition. Do we have any opposed? Please come forward. Good morning, and thank you for attending.
Good morning. Morning.
Good morning, Chair and members of the committee. John Bowders, Housing California. We appreciate the members' efforts to improve public safety, and we understand that this is a difficult issue to discuss. However, we do oppose this bill for a number of reasons. The California Sex Offender Management Board, CASOM, recently released its year-end report for 2014. On page 11 of that report, the board explicitly notes that the challenge of housing registrants, stating CASOM has repeatedly stated that the promulgation of conditions which actually create homelessness and transience among registered sex offenders while producing no discernible benefit to community safety is counterproductive and continues to be the single most problematic aspect of sex offender management policy here in California. The report notes that the number of 290 registrants and parolees who are transient or homeless now exceeds 8,000. Homelessness and transience are strongly correlated to a likelihood of reoffending. As page 17 of the report notes, transience increases the likelihood of reoffending, while the likelihood of reoffending decreases the longer that a person remains stably housed within their community. After contemplating local restrictions and exclusion zones, CASOM noted no research shows that exclusion zones are helpful in preventing reoffense. SB 54 endangers homeless children and youth. California has the largest homeless youth population in the nation, with nearly twice as many children experiencing homelessness on a given night than the national average. Many unaccompanied homeless youth report that they fled home environments where they were subjected to physical, emotional, and sexual abuse at the hand of a parent or caregiver. These youth are extremely vulnerable to additional exploitation after leaving home. In fact, California is home to 3 of the largest child sex trafficking rings in the United States. Increasing the number of high-risk offenders who may enter the homeless services system also increases the likelihood that they will have contact with an at-risk youth who has had a history of physical or sexual abuse. Designating parks as an exclusionary zone will result in harassment of non-offenders who are experiencing homelessness. Many people who live without shelter sleep at night in a local park to meet physiological needs for rest. Designating parks as an exclusionary zone is likely to result in heightened community vigilance and consequently law enforcement encounters with non-offenders who are homeless. Because many of them lack personal identity documents, local law enforcement is likely to dedicate extensive time and resources to confirming whether a person is a non-offender. Finally, we would like to highlight 2 of CASOM's recommendations on the last page of the 2014 year-end report. The first of their 5 recommendations calls for a tiered registration that would change the duration of registration, community notification requirements, and other restrictions based on the level of dangerousness of the offender. CASOM recognizes that the one-size-fits-all approach is inadequate for properly monitoring people subject to sex offense registration. This would enable law enforcement to concentrate monitoring efforts on those who pose the greatest risk to our communities. Additionally, the 5th of those recommendations explicitly advises the creation of a local exclusion zone, the very thing SB 54 would continue to do if enacted. For these reasons, we ask you to oppose this bill.
Thank you for your testimony. Sir.
Senator Stone and members of the Senate Public Safety Committee, I'm Dr. Tom Tobin, and I'm here representing as a member and as the elected vice chair the California Sex Offender Management Board, which has just been cited. I would like to refer back to something I suspect that you have already seen, but in the Taylor decision in San Diego County, the California Supreme Court stated that, as applied, there is no rational relationship between the state's legitimate goal of protecting children from sexual predators and residence restrictions. And this statement comes out of voluminous materials that the court has been provided and has reviewed, and in effect, every study, every piece of solid, substantiated knowledge about this area says residence restrictions are not effective in protecting communities. So why would we go in a direction that, according to every piece of published research, says is ineffective? The experts agree, and multiple statements have been made not only by the Sex Offender Management Board, but by national and other organizations. which is all provided in a brief paper that the management board has provided to the members of this committee. If we base policy in California on knowledge, on facts, on research, on what we know, and not on what might feel good or sound good, then it's impossible to imagine how we would go back in the direction of imposing residence restrictions on many, many California citizens if there is no discernible, provable, demonstrable effect that they're effective and mounting evidence that they are counterproductive. We've already seen the consequences of imposing residence restrictions. They are ugly. They are not conducive to increasing public safety in California. For these reasons and for many others, which I will not detail at this time, the California Sex Offender Management Board strongly urges this committee to oppose and not to vote yes on this, but to vote no. Thank you.
Thank you for your testimony.
My name is Margot George, and I'm here on behalf of the California Public Defenders Association. Senator Stone, we oppose SB 54, and as Dr. Tobin has said, the data and the evidence are in. Blanket residency restrictions don't work. They are unconstitutional, and they put our children at risk. We've talked about, you need for me to speak into the mic more. We've talked about Taylor, a number of people talked about Taylor and how Taylor, the California Supreme Court, found there was no rational relationship to advancing the state's goal of protecting children from sexual predators. And that's the lowest standard in constitutional law of finding a reason whether or not a law is constitutional. And the reason that they said it was unconstitutional in San Diego was because it forces those whom it impacts to become homeless, and it banishes them and their families. It banishes not only the offender, but their children. It forces them to relocate to rural areas, to remote regions. It hampers our notification laws being enforced because they can't find them. It hampers being able to supervise and rehabilitate those offenders. That's why the court said it bears no rational relationship to the state's goal of protecting children. And that's why if it's unconstitutional in San Diego, it's not going to be constitutional in Alameda, Contra Costa, Los Angeles, Orange, Santa Barbara, San Francisco, or any other urban county. I don't think that it's good public policy to try to force sex offenders into rural areas where they cannot be supervised and monitored, and there are not resources for them. We know that the vast majority of affordable housing is located in the most densely populated areas of any city, region, county, or state. It's also, unfortunately, for this kind of legislation where we find the greatest number of schools and parks. But one of the things that the research shows is that there is no correlation to proximity. There are individual, isolated, unfortunate, tragic stories, but the research shows there's no correlation to preventing reoffense with residency restrictions. Being forced into homelessness or being forced to live apart from your family, that's what happens to many of my clients who are registered sex offenders, impinges upon fundamental rights, and that's why it's unconstitutional. As Speaker Atkins noted earlier, that more stable housing is key to prevent reoffense. So being forced by blanket residency restrictions into rural areas where there are few jobs impinges on the right to pursue a livelihood. The last thing California needs is an unconstitutional law that forces sex offenders to become homeless while SB 54 is litigated county by county, individual by individual in the courts. I ask for your no vote. Thank you.
Thank you for your testimony. And I failed to ask if there's anybody else in the audience who was in support of the bill. If you did want to speak, please come forward. And after that, I'll call additional opponents that may want to come forward. Supporters first. Is there anybody in support of the bill that has not been heard that would like to come forward?
Again, thank you. Dawn Kapke on behalf of Crime Victims United in support. Thank you.
Thank you very much. Sorry I excluded you before. Any other supporters of the bill at this time? If not, any additional opponents to the bill, please come forward.
Yes, Senator Stone. My name is Janice Bellucci. I'm the president of California Reform Sex Offender Laws Organization. We are a statewide nonprofit, and we're dedicated to protecting the Constitution by restoring the civil rights of registered citizens. I'm also the mother of 2 daughters. California Reform Sex Offender Laws is strongly opposed to Senate Bill 54, and we ask you to vote in opposition to it today. Several reasons. I'm going to just list a few, and then I only want to expand upon one of them. One is we believe that it will, in fact, end up in endangering children, not protecting them, that it would waste limited law enforcement resources, and that it is a misguided attempt to overturn a Supreme Court decision. My final point is that, in fact, the language that's in the bill today would make it impossible for a judge to grant judicial relief for a registered citizen. As an attorney, I have, in fact, prepared writs of habeas corpus, and I have been successful to obtain relief for registered citizens so they could live with members of their family. This bill, with the standard that's being would put in force a pervasive lack of compliant housing, would make it very costly for an individual to, in fact, apply for and to obtain relief from these residency restrictions. I would like to tell you a story about one family. The registered citizen's name is Jesse, and he was prevented from living with his wife and his son. His son had cerebral palsy, and his wife was having to care for their son alone without any help from the dad. And the fact is that when he finally found out about the organization, we were able to prepare a writ of habeas corpus. He did get a stay of enforcement. He was able, after 2 years of not being able to live with his family, to join his wife and son and help to care for that son. If Senate Bill 54 passes, that would not be possible. So again, we strongly urge you and all senators on this committee to vote no on Senate Bill 54. Thank you.
Thank you for your testimony.
Micah Doctoroff, ACLU of California, also in strong opposition.
Thank you.
Dennis Garcia on behalf of the California Attorneys for Criminal Justice in opposition.
Thank you.
Michael Madonia, former registered citizen from Sacramento. I am opposed to this this bill. I'd like to say that I was having a difficult time getting a certificate of rehabilitation. It took 35 years for something that I had no other offenses for and hadn't offended for 35 years. It is not easy to get off. So don't think that just because you've been good or followed all the laws, it's going to be easy just to get off. It's not a quick get off, and I guess I feel lucky to get off. But I did everything I could. I followed all the rules, the laws. I sought counseling, and it was very beneficial to me. And one of the biggest things that I found, I think is more important, is that a lot of the people, I think, at least me, wasn't aware of the simple things as how dangerous or how harmful it was just to touch. And actually, I didn't even touch. but it's not funny, but what I'm pointing is, if there was some public service announcements or some sex education, because you can't rely on the parents, that would be nice if you could, but a lot of people are just unaware of the harm that they're causing. And I think that's one of the problems, and I think you could do something maybe to let people know that just the mere talking and touching, things like that are much more harmful than people realize. At least that's what I was brought to understand by my counseling, and it makes sense to me now. Thank you.
Thank you. I'd requestfully ask for the testimony now that if you've heard something you've heard before, please don't duplicate it. If you could just kindly say your your name, where you're from, and whether you support or oppose the bill. Thank you.
Frank Lindsay, 36 years as a registered citizen. I strongly do not support this. When there is no evidence that supports the action, I think the bill should be pulled.
Thank you, sir. Appreciate your testimony.
My name is Mark Walsh, registered citizen, resident of San Francisco, American citizen, citizen of the state of California. My mom is a daughter of the American Revolution. My father's parents came through Ellis Island. I grew up an hour from the Liberty Bell. I'm hearing a lot of talk about, you know, the legislation and constitutional issues. Constitutional issues are very important to me. And I really am at a loss right now of what to say. I guess my question would be is, when are we going to come out of the dark ages and talk about this based on facts, empirical evidence, well-researched data from experts, and not live by fear-mongering? There is various different categories within these offenses, and most of those have nothing to do with children. And to lump sum, we have created a segregated class in this country. We have the history of such things, the Scarlet Letter, the McCarthy hearings. We just had a Supreme Court ruling about the civil rights of a particular population. And they had to fight for how long for that? Just to be recognized for that. And how long is it going to take for people to have courage to stand up and say, this is wrong? I strongly oppose this. California is one of only 4 states in the United States that does not have a tiered registry. And the registries do not, 95% of the people on registries do not reoffend. That data is from the U.S. Justice Department. I strongly oppose this and ask you to come out of the dark ages. Thank you.
Thank you for your testimony.
My name is Bruce Hamlin. I'm a business owner in Orange County, California, and I am not a registered citizen. If the senator's true motivation was to improve public safety, she would have taken the California Sex Management Board's recommendation and introduced legislation for a tiered registry. I agree with the gentleman that just spoke. We need to come out of the dark ages. We need to make sure that this subject, it's a very emotional subject to a lot of people, but I strongly oppose this bill.
Thank you for your testimony.
Good morning. My name is Russ Atkinson of Pleasant Hill. Restricting housing against any minority divides people, creating an impenetrable barrier to meaningful gains and equal job opportunities and normal family and community life. It also cripples the efforts of responsible government leaders to achieve the unique American goal of ensuring equal opportunity for all. For these reasons, I respectfully ask you to vote no.
Thank you, sir.
Good morning. My name is Katya Abelski, and I'm here with All of Us or None, and also in strong opposition.
Thank you, ma'am.
My name is Ryan Palmer. I'm here with Legal Services for Prisoners with Children, and I'm also in strong opposition to this bill.
Thank you, sir.
Deirdre Wilson on behalf of ESSE and California Coalition for Women Prisoners in opposition to this bill.
Thank you for your testimony.
Hi, I'm Pam. I'm a little bit nervous, but I drove 3.5 hours to be here. It's going to probably be 2 hours to go home. It's cost me $300 overnight, and I have something to tell you. And that is that our Constitution was written specifically to protect us from you, from our government. It was not written to protect us from the general population. And the right to know somebody's criminal history, your neighbor's criminal history, that's not an enumerated right. It is a segregation and discrimination law that's being put forth here today. And I would say that it's built on bigotry, hatred, fear-mongering, stereotypes, things that we know are not true. I would ask you to please remember your oath of office and remember what our Constitution is for and what it is not for, and vote no on this bill. Thank you.
Thank you for coming. Is any others in opposition to the bill at this time? If not, we'll go to questions. Senator Monty.
Thank you, Mr. Chair. And Senator Renner, just so I'm clear, this is a tough issue, and I think it's important. This bill does not create a tiered registry, and I do think society would benefit if we had a way to, I don't like the word profiling, but to categorize severity of past convictions and data-based projections of potential risk. But I hear the testimony of concern of our communities potentially put at greater risk when people are homeless and transient, as opposed to having a fixed location home address. But just so I understand the bill, my question is, as I understand it, this bill would create an appellate review at the Superior Court level where the parolee who seeks an exception to the 2,000-foot rule would make their case to this Superior Court Appellate Division. Is that accurate?
Yes.
And what would they have to, what's the burden, what's the criteria they have to prove? And if they're successful, then is it my understanding there's a waiver then where they can rent property within that 2,000-foot zone? Do I have that correct?
Yes, it's our understanding that the in-rate tail, obviously in San Diego, there was such a sparsity of housing that it was an easy decision. We would anticipate, and we indicated earlier, I'm happy to accept an amendment to the effect that the in-rate Taylor standard would be the applicable standard. We couldn't do otherwise because the lower court's going to follow the Supreme Court. But to clarify the language in the bill, the petition would be, as you say, to the Appellate Division and Superior Court where they could look at the facts. And so in San Francisco, we would imagine that they would do exactly the same thing that was done in San Diego. They would say it cannot be constitutionally applied in this county.
What evidence would have to be put forward?
It would be the density of housing. It would be the and we, I think we
and presumably,
maps, which
I saw the map.
Immediately demonstrate.
Right. But then the person seeking the waiver presumably would have to hire a lawyer.
Again, this could be addressed because in the case prior to In re Taylor, the Supreme Court kicked it back to the intermediate appellate courts to be remanded to the superior courts for findings. So again, this bill would allow the appellate division to consolidate the cases and ostensibly require the public defender's office or provide funding so that they could do an appropriate study. That's what's happened in re Taylor. I mean, it wasn't expressed in the terms, but when they kicked it back down for an 8-day trial in San Diego, since it had been ordered by a higher court, they conducted the study. They came to the conclusion.
So would you have any data that would show what percentage of people that may be homeless and transient today would have the resources and the ability to pursue an appellate review in a local superior court?
We have a stalemate now. We have a decision in San Diego. We have 57 other counties where there's been no decision. You can leave it alone, and it can fester for the next 5 or 10 years, or you can create a path so that individuals seeking relief can get it at the county level. Be happy to work with staff to provide that there would be adequate funding for that mechanism.
Right. And just a final question then. There's currently a requirement for registered sex offenders to report to their parole officers, and that when they do have an address, that is a matter of public record. Is that correct?
I think it's a matter of public record if they're on the registry. Not every sex offender is on the registry. We try to narrow the focus by enumerating the offenses that would be covered under the bill by cross-referencing the one strike rape law, so that there's no gray area.
Right.
I can enumerate the offenses if you wish.
No, I see it. I've got a copy of that. Thank you. Answered my question. Thank you, Mr. Chair.
Thank you. Senator.
Senator, thank you for your work in this area. There are a lot of emotions on all sides, and I appreciate how difficult it is to try to maneuver around and through it all. I was wondering if you could share your thoughts about the proposed changes in how you measure distances. So the bill does that in a different way than is currently measured, and I wanted to understand better what your thinking was there.
There were, in a couple of counties at least, there was some question as to whether this measure was as the crow flies, or if you had a school on one side of the river in a housing development on the other, whether it would apply there because it was technically less than 2,000 feet. So what we're saying here is if there's no practical path, if you have to cross the river, you have to get on the freeway, there's a physical or natural obstacle, that it would have to be measured around that obstacle and therefore open up more areas.
Right. So in doing so, I guess I don't understand, if you looked at it from the point of view of a neighbor, it seems that you're providing greater leniency in a neighborhood for where someone may be able to live when previously they would not be able to live.
To some degree, that's true, but in discussing it at length, we didn't think that the public, this was a fairly high-profile element of an initiative that had more than 70% support. Had the support of then Governor Schwarzenegger, then Attorney General Edmund Brown, and so it's basically that we don't think they intended that it was a technical kind of thing, that the 2,000 feet didn't mean that you had to drive to the I Street Bridge, cross over, and then find a home on the other side. So if there's an obstruction that makes it more than 2,000 feet, that's what we thought that the voters probably intended.
And maybe you could address the issue of where is the role of neighbors in this process, this new legal process that you're suggesting? How do neighbors get notified? Who's going to speak for them? And what's their ability to be informed about a potential change in their neighborhood that a court decision may create?
Well, one way or the other, I mean, we have a relative stalemate now. We have a decision that applies in a single county. We have uncertainty in other counties as to the applicability. So I think clarity would help the neighbors and everyone else.
But it may be, my concern is that what's the ability of a neighborhood to defend themselves in any kind of court action that may be contemplated? Who's going to notify them and give them the ability to have their voice be heard in the process? That's what I'm feeling to see in this proposal.
Well, the enforcement level, remember this is a civil standard. That is, no one goes to prison because they failed to live more than 2,000 feet from the school. The enforcement is generally by the county, which would be by the sheriff, who's elected by the people. So, I mean, there's not a direct democratic process in terms of each individual seeking to defend their homestead. Here, it's a measure that would either be enforced or not enforced by local elected officials.
All right, thank you.
Are there any more questions from members?
Yes.
Yes. Senator Stone, and just let me ask, Senator Stone, did you take testimony in favor and testimony in opposition?
Yes, ma'am.
Okay, thank you. Senator Stone.
Thank you.
For the close. Yes.
Thank you. Getting back to the issue of Senator Monning's concerns that you have somebody that has to go to this appellate division of the Superior Court to find housing. If that person is impoverished, which most of our sexual registrants in these urban areas are, they would still be qualified to get a public defender to help them through this process.
That's what happened in the underlying case.
Okay. Senator Renner, I appreciate you bringing this forward. In my study of this, I just want to make sure I understand. I'm not a lawyer. Let me qualify that. The appellate court found the only unconstitutionality of this law is the way it was applied.
Correct.
Not the way that it was written.
Correct.
Okay. So in San Diego, there were conflicts, and certainly the opponents bring up very good points that we don't want homeless sex offenders certainly preying on our youth. And it seems as though this bill has done a couple of things. One, it has looked at the paths of shortest distance to qualify for that 2,000-foot distance. It's not the way the crow flies, the way I understand it. And two, and I've heard that the opponents are saying that we're going to be making these people homeless when in fact you provided a mechanism so that we don't make them homeless. And in looking at statistics, child sexual abuse involving sexual contact between an adult and a child has been reported by 20% of the adult women and 5 to 10% of men in a number of studies. These studies suggest a huge disconnect between the number of offenses and the number of known offenders. Children often wait until adulthood, as we've seen many times in the media, to disclose the sexual abuse. And studies conclude that as many as 90% of sexual abuse cases are never reported to authorities, which is alarming. And according to the U.S. Department of Justice, 74% of sexual assaults are never reported to authorities. And then we go back to Jessica's law, and I think you know the author of that law, and I believe it passed by over 70% of the electorate. Is that correct?
Right.
Madam Senator?
That's correct.
70.5. So there's been strong public support and concern for these very dangerous, and you've identified these strike, rape and violation of certain paragraphs, rape, spousal rape, sexual penetration, lewd lascivious acts with force, sodomy and violation of certain paragraphs, oral copulation, lewd and lascivious acts, continuous sexual abuse of a child. I mean, these are very serious issues that you've identified. And I must say that while my very good friend, Senator Anderson, are good friends today, we were rivals about 4 years ago. And I think that the senator will remember that when we were running for his present Senate seat that he has, there was this terrible crime that we all will remember involving a gentleman by the name of John Gardner, who once lived in my county and went to San Diego County. And at the end of parole, before Jessica's law came in, had his GPS device taken off. And later, he kidnapped and murdered Amber Dubois and another young child, Chelsea King. It's these kinds of things that we have to protect these kids. And I understand also the concern about tiering the different levels of sexual registrants. That's certainly not for discussion today, but probably will be a discussion in the future. You know, you have an 18-year-old that exposes himself over a freeway overpass and registers as a registrant for the rest of his life versus a man that rapes a child, rapes an adult. I certainly understand those concerns, but that's not what we're discussing here today.
It's not part of Jessica's
I think it's important that we err on the side of protecting children, especially in these more urban areas. And I think that you've made a very common sense approach to basically responding to the Supreme Court that says, we got a problem. This is not a one-size-fit-all. It seems to me that you've mitigated those concerns and came up with an appropriate process, which I hope is a fast process. I hope it's not a belabored process, that they deserve the due process to find appropriate housing so they can get the treatment. And certainly the public deserves to also know if they are going to be located within a closer distance than that which is allowed by law.
Are you moving the bill?
And so with all that said, Madam Chair, thank you for your patience. I would like to move the bill.
Thank you. Would you like to close, Senator Ryan?
Yes. Some of the opposition, you know, whether you oppose or support it, I think there needs to be a procedure, and I think going to the local appellate court is much better than ending up years later, this has been probably 5 years in the case in San Diego to do that. So I think we need a procedure to be in place for that to happen. You all have the map. You understand pretty much Los Angeles, San Francisco area, San Diego do have a lot of parks and schools that doesn't happen. I often get calls because I'm in Los Angeles County, and a lot of those sex offenders end up in the rural districts in the county, which are my county, because they can't live 2,000 feet away from a school or a park in Los Angeles. So I know both sides. I think it's more important to protect our citizens and the children than it is to protect the child molesters who are living across the street or down the street from a park that may be tempted. It's more, I believe, in their best interest to live somewhere or with a family, which makes sense, and that's why they can appeal it this way, and it'd be much easier to appeal it this way. And, I disagree that it's more affordable housing in cities. I think that's just the opposite. Somebody mentioned that. You can barely live in a city if you have a couple full-time jobs in San Francisco and the Bay Area. So I think it's very important that they spend time with the family and their rehab. But you need to have a rational standard. And I think this procedure is a rational standard. When you talk about the tiering, it has been tiered because these are the worst of the worst rapists and child molesters. These aren't somebody who's naked jumping off the bridge or whatever that might be. So I would ask your support, and am flexible with the decision and the amendment that we were talking about with the public safety staff. So I'm willing to work on this, but still agree that it's possible for these citizens and these child molesters to live away from parks and schools, and or get permission to live with family that can help. So I'd ask for an aye vote.
Thank you. The bill's been moved. I have to say that, this was predicted when the initiative was out there and passed. And it was. Unfortunately, I have read all the letters. I had to be presenting a bill in another committee. And I cannot support the bill today, Senator Runner. I'm particularly concerned about the information we received from the Sex Offender Management Board. These are people who are experts. They spend their time looking at these problems, and they're feeling that these restrictions don't work and may actually harm public safety are very compelling to me. I understand what you're trying to do. We all want to protect our children, but I can't support a bill that does this at this time. I would really urge you to sit down and work with the Sex Offender Management Board and maybe come back with a changed bill or a different bill. But today, I'm not able to support your bill.
Thank you. And I know in the past, it didn't get through the legislature. That's why it went to the proposition, and 70.5% of the people, citizens of California, voted for it.
Right.
So, thanks.
Hancock?
No.
Hancock, no. Anderson? Aye. Anderson, aye. Glazer? Leno? Liu? No. No. Monning? Stone? Stone, aye.
Okay, that bill is on call.
Thank you.
Thank you. I see. Is he here?